one slightly off-topic point. It's funny how Heitzman's dissents can be very influential as the law develops later on, as we saw
Sure.
with Bellamy. But this raises a question I'd ask Bill Quirk, and we hear these questions routinely all the time. Is your client an American citizen? How should we deal with that?
Well, either is or isn't. Okay. So,
Yeah, but you're not the expert, Bob. Bill is.
well, I understand that, but I mean, well, let me see it. If one of your clients is asked that in municipal court, how should you respond to it?
You've got to answer with the truth. And that's something that you should be talking to your client about way before you get to the point of making a plea in front of the municipal court. It should be something that's one of the first 3 or 4 questions that you ask when the person comes into your office and you're consulting with them. At this point in our current administration, knowing who you are dealing with is incredibly important in determining what's going to go on through the process of your case. So finding that out is incredibly important. And it's not enough to just simply have that person say, I'm a citizen. You need proof that they're a citizen. They have to show you something that you can put into your file so that if, God forbid, they were lying to you, you have something to protect yourself down the road.
Well, Bill, I routinely ask for those naturalization certificates or birth certificates, but going back to the original question, in municipal court, we always have that right to remain silent and not answer questions. Obviously, if you're dealing with immigration and applying for some kind of immigration status, like you said, you have to be scrupulously honest, forthcoming. But in the municipal court, would it be better to just say, we'd rather not answer that question to the municipal court judge?
I think that's going to run you afoul of a number of different things, John, in all honesty. I see where you're coming from, but the fact of the matter is that basically everything is discoverable in terms of an immigration matter in the future. So when I get inquiries from immigration, a lot of times I'm being asked for things like plea colloquies. And, if you are being obtuse, if you're being evasive to the tribunal, there are certainly situations where a USCIS officer or the immigration court could make a negative inference against your client because of that. I think that it's just best that you tell the truth and deal with the consequences as they may be.
What if it's the defense attorney just running interference for the client? Judge, we'd rather deal with that right at this time.
I think the judge is going to come back to you and say, I'm obligated under the guidelines to ask you these questions, and I'm supposed to get answers because, this could have an impact on PCR in the future. This could have an impact on possible litigation in the future. I need to get an answer. If you want to go down that pathway and say, I feel like that my clients, it would be better in my client's Fifth Amendment interest to not say anything. I don't know if the judge is going to take your plea at that point.
Well, we're not talking about a plea. I'm just talking about at the first appearance. You know what I mean? When we're going through the process. Obviously, one could argue that just being an undocumented immigrant in this country makes you breaking the law. They'd be confessing to a crime by answering that question, as opposed to just not dealing with it and letting them deal with the present charge on its merits.
John, I want to change this, just take a slight turn from what we're talking about. And Bill, this is really for you, okay? John and I do post-conviction relief applications all the time when there's immigration consequences that are in play. And what I will do typically is I basically do 3 things. Number 1, I want to get a transcript of the opening statement. I want to get a transcript of the first appearance. And I want to get a transcript of the plea colloquy, all right, to see if all these things were in play. And I argue that on the PCR that it was not done in violation of the Supreme Court's 0911 directive. Sometimes there's an issue as to whether, because of language issues, whether or not the defendant actually understood fully what the judge was saying and the implications of what the judge was saying. And I also point out that up in Superior Court, they have a plea form that ticks off all these direct and collateral consequences, including very, very significantly immigration consequences. For drunk driving, since there's so much going on, they should have a plea form for drunk driving too, but they don't. And I bring up that as well. I say all the time, say, look, if it was that important, they should have a plea form. So there's no doubt the defendant knew what he was getting himself into. by pleading out.